Good morning, good afternoon, and good evening. I will wait a moment before continuing because I see a few people are joining us. I think they've stopped, and it's probably as well I continue, as our timetable is very tight and very precise. But first, may I begin by thanking the Minister, Ms. Indrani Raja, SC, for her most impressively pre-recorded warm welcome, what I can only describe as a brilliant summation of the forum's purpose and achievements to date, and her strong support for the conference. May I next welcome, on behalf of the steering committee, everyone to this, our third conference, and a particularly warm welcome to those jurisdictions who are joining us for the first time, and those jurisdictions will be outlined in the progress report that is to follow immediately. We have a very, very full program, and we look forward to your participation in it. And I think we in the steering committee look forward very much to hearing your ideas for our future work program. Can I add just one brief footnote? One of the aims of SIFOCC is to bring us all together. And at the end of this session, and at the end of the closing session tomorrow, the marvelous team in Singapore is going to take a group photo. So please have your camera on, look at it in a way in which you wish to be recorded, and please remember to do so. I will try and remind you at both times. I will say more by way of thanks and about our future tomorrow. But before I hand over to Chief Justice Sundaresh Menon, may I, on everyone's behalf, thank him, his superb team, in making this online conference possible. We were all very disappointed last year that we had to cancel the very interesting prearranged program, and that led us to be cautious, and I think with the benefit of hindsight, rightly cautious, about holding an in-person meeting now. But we've got this online conference. The preparation has been immense, the resources are enormous, and the technology is overwhelmingly impressive. May I thank you, Chief Justice, and your team for everything, and hand over to you now.
Thank you so much, Lord Thomas, Chief Justices, judges and friends from all over the world. Welcome to the third meeting of the Standing International Forum of Commercial Courts. I'm delighted and grateful in equal measure to welcome you today. Delighted because we're able to come together to build on relationships established when we last gathered as a group almost 3 years ago in New York, and grateful because we can do so despite the many challenges brought about by the COVID-19 pandemic. I recall our early discussions about the focus of the third meeting of this forum, and we concluded then that we should study a range of aspects relating to the emerging partnership between justice and technology. That has turned out to be prescient. COVID-19 has changed the world as we knew it, and among its many effects has been the dramatic acceleration of that partnership. The pandemic has compelled us to develop new ways of working in order to accommodate the environment we find ourselves in today. The focus on technology was undoubtedly topical, but it has also been enabling. And so where I had hoped, together with my colleagues, to welcome you personally to Singapore last year, we gather today using technology to bridge distances and to overcome obstacles. This forum has provided and continues to provide an extremely valuable platform for all of us to share ideas, experiences, and innovations. And I'm sure we will all learn much from our discussions over today and tomorrow. Let me, before I turn the floor back to Lord Thomas, express my deep and heartfelt gratitude to Lord Thomas and the whole steering group for having guided this forum, to the forum secretariat led by Sir Robin Knowles and Grace Karrass, and to my outstanding team led by my divisional registrar of the Singapore International Commercial Court, Pang Xiao Chung, and Yuna Kung, and supported by our Office of Public Affairs. They have all done superb work to make this meeting possible. I welcome you once again and wish you all an excellent time, and I hope we will meet your every expectation.
I would now ask Sir Robin Knowles and Grace Karrass if they would raise their hands so they can be unmuted. Raising your hands is the way to make sure that everyone is unmuted when they wish to speak. Sir Robin.
Thank you. SIFOCC is now in its 4th year. Its membership exceeds 40 jurisdictions from 6 continents and from common law and civil law traditions. 12 of the jurisdictions are in the G20.
We are delighted to welcome Brazil, India, Jamaica, Kenya, South Korea, and the Bahamas to their first full meeting. After the New York meeting, SIFOCC established 2 international working groups drawn from across the membership, and in a short while we'll hear from the chairs of those working groups. We'll also hear about the continued work of the SIFOCC Judicial Observation Programme.
SIFOCC has now published 2 editions of its Multilateral Memorandum on Enforcement of Commercial Judgments for Money, with the participation of 40 jurisdictions. The COVID-19 pandemic brought truly significant challenge to all. Member jurisdictions from all parts of the world responded to the steering group's call to pool and share their early experience on using technology in a first SIFOCC COVID-19 memorandum of May 2020. A similar collective effort has seen the publication this week of a second SIFOCC COVID-19 memorandum, this time addressing the future use of technology experienced during the pandemic.
SIFOCC has also taken the opportunity to work in partnership. In the summer, we held a roundtable jointly with the Commonwealth Magistrates and Judges Association, and another to come. In the next months, there will be seminars with the Commonwealth Lawyers Association and featuring at London International Disputes Week. Earlier this week, the SIFOCC website carried interviews with senior judges from the US and Malaysia to celebrate International Women's Day.
SIFOCC's 3 objectives remain. First, to share best practice. Second, to assist courts to work together to make a stronger contribution to the rule of law. Third, to support developing countries in their work on resolving commercial disputes. The impact of all this goes beyond commercial dispute resolution. It is striking that 17 of the delegations at this meeting are led by a Chief Justice. The President of the Federal Court of Justice of Germany puts things in this way, quote, "In times where we observe the rise of unilateral ideas worldwide, it gives hope to remember that the fortunes of the countries already are inextricably linked by business and commerce, and hopefully will continue to be. In this respect, effective and predictable justice on commercial matters, as promoted by SIFOCC, is not only an essential element of international trade relations, but may also contribute to ensure freedom, justice, and prosperity." End quote.
As you know, this meeting has 3 live judicial roundtable discussions, but in addition, the platform offers the facility for written discussion of 3 further subjects throughout today and tomorrow. The closing session will address the present and future role of the world's commercial courts and for SIFOCC.
All delegates are encouraged to participate in the live judicial roundtable discussions with short comments or questions, and in the written discussion. In the spirit of SIFOCC, the aim is to draw in and share perspectives and experience worldwide. Everyone has something to contribute and something to learn, and this is also an opportunity to identify further areas for collective or collaborative endeavour.
For the first time, all the live sessions will be recorded. This is in order that after appropriate editing, we can make them publicly available after the meeting. We envisage increased public engagement with technology and regional activity helping with this.
At all times, the steering group warmly encourages member jurisdictions to raise ideas. SIFOCC's website is there to be made the most of. The Secretariat is here to help. As judge with day-to-day responsibility for SIFOCC, I would like to pay grateful tribute to the Secretariat led by Grace for all their work on SIFOCC.
Robin and I would together like to thank the SIFOCC membership. Without your contributions, this work wouldn't be possible. And we'd also like to express warm thanks to the Singapore team. It's truly been a team effort on this third meeting, and we've really enjoyed an excellent working relationship.
With our thanks, back to Lord Thomas to bring in the chairs of the SIFOCC working groups.
We next turn to look at the first report, which is the report on international best practice in case management. And I would ask Chief Justice James Allsop and Sir Peter Gross, who are the chairs of this group, to raise their hands so they can be unmuted. James, I think it's over to you.
Thank you. I think Peter was going to start, but I'm happy to.
I'm happy to start as we, if that's convenient.
Of course.
Chief Justice, thank you and the hosts in Singapore for hosting this important gathering virtually. It is much appreciated. My thanks too to Sir Robin Knowles and the Secretariat for the excellent work done by way of preparation. It was a privilege to co-author this report for SIFOCC, the report on case management, and a pleasure and privilege to have had the opportunity of doing so together with Chief Justice Allsop. Real thanks too to the members of the working group and the consulting experts drawn from so wide a spread of jurisdictions whose contributions were all most valuable. It is gratifying that the report has been adopted and published by SIFOCC. We hope it will be put to good use in the time to come and will assist in furthering SIFOCC's objectives. Today, I do no more than highlight two principal themes from our report. The first is that case management exists to assist in the resolution of commercial disputes. It is about mindset. It is emphatically not about process for its own sake. Successful case management, forming an integral part of the judicial role, requires judicial leadership, together with the cooperation of the legal profession as a matter of professional best practice. Secondly, this ghastly pandemic has resulted in the welcome acceleration of the use of technology in commercial litigation and arbitration. Justice in this area has not gone on hold. Commercial law has successfully adapted to remote hearings. The relevance of case management is undiminished. Important as case management is and has been to hearings in person, and I think we all remember hearings in person, It is likewise a key ingredient in the successful conduct of Zoom hearings, the new normal and likely to remain so central a part of the future landscape. Thank you. I hand over with pleasure to Chief Justice Allsop.
Thank you, Sir Peter. It was both a privilege and a very great pleasure to work with Sir Peter Gross and the members of the working group and consulting experts on this project. The short document that you have, it's only a little over 4 pages, is deceptively simple. However, its form and approach contain and reflect important considerations of the kind Sir Peter mentioned. Effective case management is not all about rules. Indeed, it has very little at all to do with rules and strict procedure. There is a saying, there is only one rule, there are no rules. The document seeks to guide by approach and theme, not by detailed prescription. The guiding considerations are active, energetic problem solving, seeking a solution to practical problems of dispute management, and the development of a legal culture to participate in and underpin this approach. These considerations require engagement with and education of colleagues, the profession, and the commercial community. So the document is not rule or procedure focused, but directed to approaches, themes, and, as Sir Peter said, mindsets. We will come out of this pandemic with a renewed focus on technological assistance. But the human engagement of the courts, the profession, and the commercial community is at the heart of effective cooperation to reduce the costs of justice and increase the quality and acceptance of commercial courts as indispensable parts of the international rule of law. May I add my thanks to Chief Justice Menon and the team that has worked so assiduously in Singapore, and to the steering committee and all those in the Secretariat who have made this third important forum a reality. Thank you.
Thank you very much indeed for such a wonderful report, and it has the great benefit, as you've said, of being so concise. May I now turn to the second report, that of the second group, that on international enforcement of judgments and common themes therein, and ask Sir William Blair and Judge François Ancel to raise their hands so they can be unmuted and present their report. Whichever of you is beginning, do begin. Oh dear. Judge Ancel, something's happened to Sir William.
Yes,
do you wish to...
Do you hear me?
Yes, perfectly.
Okay, perfect. Well, Sir William Blair first.
Thank you very much. First of all, let me express my thanks for the hosts of the meeting. And I also thank very warmly Judge François Ancel and the working group for the work that has been done on the second report that SIFOCC has produced. At the previous meetings of SIFOCC in London and New York, the subject of enforcement by the courts of one country of commercial money judgments given by the courts of another country has been identified as an important area of study. As is well known, in the case of international arbitration awards, the New York Convention has been highly successful in achieving global coverage. There is, however, presently no equivalent applying to court judgments. The Hague Convention on the Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters, adopted in 2019, is an important step towards a truly international regime. But there is no certainty as to when or indeed whether this convention will come into force. And in the meanwhile, we must rely on the rules of domestic jurisdictions. In 2018, the Forum published the first edition of a multilateral memorandum, bringing together summaries by judiciaries as to the rules applicable in their own jurisdictions. As Minister Indrani Raja mentioned in her welcome remarks, in December 2020, the Forum published the second edition of the memorandum, which considerably expanded its scope. It now includes summaries from judiciaries in 32 states. It's included in the conference papers, and the working group would like to thank Sir Robin Knowles for his work in this regard. To be clear, the memorandum does not purport to be of binding effect, is not intended to signal the enforceability of commercial judgments, and does not seek to set out principles such as those set out in the Hague Convention or in the Asian Principles published in 2017. The aim has been a different one, namely to summarize as simply and as transparently as possible how the contributing judiciaries each go about enforcing the commercial judgments of each other. So far as we're aware, this exercise has not been conducted before, and certainly not on this scale. The task of the working group has been to provide a commentary on the memorandum, which seeks to put the individual contributions into their true global context, and which, while recognizing differences of approach, seeks to identify common themes. Reciprocity is, of course, the basis of the many bilateral and multilateral agreements entered into between states. But the coverage achieved by such agreements is much too patchy to provide a coherent global system. A particular interest of the working group, therefore, has been as to the rules applied by courts in the absence of such agreements, and whether the contributions appear to show tendency towards convergence between common law and civil law systems. Perhaps the most important point to note is that emerges from the memorandum is that the starting point for courts is not that foreign money judgments are unenforceable. On the contrary, courts have for a long time been prepared to recognize such judgments on various grounds, such as comity, or on the basis that they found a cause of action independent of the underlying obligations. The question is as to the criteria that courts apply in doing so. Here it is possible to discern some common themes that come through the memorandum. And here I give the floor to Judge François Ancel.
Thank you. Thank you very much, Sir William Blair, for giving the floor. It was a great privilege for me to work with you and the group. And it's also a great privilege for me to intervene in this opening session. As mentioned, the scope of this memorandum, covering both common law and civil law, enables us to identify the main prerequisites to recognition and enforcement of foreign judgments and the substantive conditions that appear to be generally required by the courts in either system. Some courts may treat particular matters as requirements for recognition and enforcement of foreign judgment, and others as potential bars to recognition and enforcement. The matters are not necessarily expressed in the same terms or in the same terminology, but overall the effect is the same. The first principle that is generally found throughout all contributions is that the merits of the judgment are not reviewed by the court ruling on recognition and enforcement. This appears to be the position across common law and civil law judiciaries, and this is striking and probably the most important proof of the willingness of the courts to promote the recognition and the enforcement of foreign judgments. As this limit generally accepted, the courts will then carry out the following checks: the jurisdiction of the court of origin, according to international criteria such as the connection of the defendant to the country, the finality of the judgment, in the sense that it must be a conclusive judgment between the parties on the merits of the case. Also, other factors may be treated as grounds for recognition or as bars to enforcement in their absence. For instance, the fact that the defendant has had a proper notice of the proceedings and that recognition will be withheld if the judgment was obtained by fraud. The judgment may also be withheld on public policy grounds where, for example, there has been a lack of due process. An interesting feature of the memorandum relates to reciprocity. Reciprocity is by definition a feature of the mutual recognition treaties between states. In some civil law courts, reciprocity is also both a requirement of and a ground for recognition and enforcement by judicial process in the absence of a treaty. This is not the case in common law. Reciprocity may be a difficult requirement to satisfy if it depends on pre-existing enforcement by court in the country of origin. There appears now to be some momentum in Asia to bypass this problem by what is called presumed reciprocity. Lastly, something must be said about proceeding. All contributions require, in the absence of treaties, an action brought in the courts. The judicial treatment offered to the parties is therefore essential to demonstrate the effectiveness of a system. Everyone will understand that the longer and the more expensive this treatment is, the less effective it will be. In common law, it may be disposed of by summary judgment procedures. The conclusion of the working group is that the summaries in the memorandum suggest a gradual drawing together of the approaches of the civil and common law judiciaries, placing emphasis on the proposition that foreign commercial judgments for money may more generally be recognized and enforced subject to the well-recognized requirement we have outlined. So comments and additions from the memberships to the draft commentary are welcome and are requested by 19th of March. The working group, whom I thank again for their assistance, will then settle the commentary and it will be headed to the second edition of the memorandum, which will be published as a single document in April. Thank you very much, and I take the opportunity to thank all the organizers of the SIFoCC, and in particular Lord Thomas and the Chief Justice Menon for their opening remarks. Thank you.
Well, thank you very much, Sir William and Judge François Ancel, for such a pioneering piece of work. And finally and briefly, we now go to the third of the opening remarks, and that's to do with SIFOCC's judicial program of observation and study. And Chief Justice Zaya Surya of Sri Lanka and Justice Ainam Alami are going to speak briefly on this subject. If you can raise your hands so you can be unmuted. Do start, please.
Good morning, good afternoon, and good evening to all delegates from around the globe. We are now connected together under circumstances that prevent us to be together at one venue physically. Participation at 2 SIFOCC programs on judicial observation and study has given an opportunity to Sri Lanka to consider how best the current processes could be further improved and thereby strengthen the judicial process. Both judges who took part in 2018 and 2021 are joining as delegates for this meeting too. Through this program, we have had the exposure to 2 important jurisdictions, namely the United Kingdom and Singapore. Mr. Mahinda Samewardana, Justice who took part in London program in 2018, is now a judge of the Supreme Court. He is appointed the chairman of the Commercial Law Reforms Committee by the Honorable Minister of Justice to examine and propose necessary amendments to bring the commercial litigation process in Sri Lanka to be in line with international standards. Judge Priyantha Fernandu, who took part in this, namely the United Kingdom's program, is a sitting judge in one of the 3 divisions of the Commercial High Court. He is now a judge of the jurisdiction over commercial matters as stipulated by the Special Provisions legislation enacted in 1996. I am also happy to announce that steps are underway to further strengthen this special court by introducing an additional 4th division to focus on commercial matters relating to foreign investment. In Justice Samewardana's words, I quote, "The Judicial Observation and Study Program is truly an amazing program, which is distinct and different from other foreign programs," close quote. He had had the opportunity, I quote, "to sit with Justice Knowles on the bench, probably the best modern commercial court complex in the world," close quote. Through this first-hand experience, he had seen how efficiently the UK commercial courts put theory into practice to resolve commercial disputes in an effective manner. The experience gained on the environment in the paperless court and on the commercial court guide, which includes the procedural rules, which has the flexibility to adapt to the exigencies of the particular case, had been truly amazing. Even though this year's program is conducted remotely, Judge Priyantha had the exposure to the workings of the Singapore International High Court, which is equally highly informative. The opportunity to have a closer look at best practices in place to enhance the efficiency in the system had been a great asset. He has gained first-hand experience on how 4 special mechanisms in place would enhance the efficiency in the system. Exposure to special mechanisms such as divisionary, facilitative, monitoring and control, and depositive mechanisms is truly remarkable. Experience on remote hearings in place due to pandemic, the guide on best practices for remote hearings, May 2020, special measures in place in the system to enhance efficiency, such as hot stubbing connected to expert testimony and red fern schedule in sorting admitted facts and documents had been a remarkable experience. Mentoring sessions with Judge Kannan Ramesh had given the opportunity to have a closer exposure to the system. The exposure to these 2 jurisdictions has given the opportunity to Sri Lanka to focus on developing and improving case management strategies and expanding legal practices with the objective to gain an efficiency that benefits all users of court as well as the entire fabric of commercial activities of both local and international. We have no doubt that the SIFOCC, which promotes discussion and its application of best practices in dealing with commercial litigation, will go from strength to strength. I wish her all the best in her endeavors to make a lasting impact on the rule of law. In concluding, I wish that all of us be blessed with courage, strength, and luck to overcome these difficult times and continue with our joint efforts to further strengthen the judicial processes in relating to commercial matters. Thank you.
Thank you very much, Chief Justice. And Justice Alami, if we can be very brief, time is under considerable pressure. Thank you.
Good afternoon. It is an honor and a privilege to give these short remarks at the third Standing International Forum of Commercial Courts meeting hosted by the Singapore Supreme Court. In July 2018, with the assistance of Rule UK in collaboration with the Standing International Forum of Commercial Courts, I was nominated by the Chief Justice of the Gambia to participate in the Judicial Observation Programme visit to the commercial courts of the UK and a subsequent participation at the second SIFOCC conference in New York in September 2018. The aim of the Judicial Observation Programme was to build our capacity as judges from developing countries through a one-week visit to the business and property courts in London. The program was such that we were hosted by a dedicated judge, Justice Robin Knowles, who ensured that we engage in discussions and meetings with various judges and judicial staff in the commercial courts. We were able to observe and adopt some best practices in the commercial courts and shared the experience of the SIFOCC meeting in New York in 2018. The visit, being the first of its kind, created a peer-to-peer learning opportunity for the three participant judges, Justice Mahinda from Sri Lanka, Justice Anna from Uganda, and myself. Having an experienced judge like Justice Knowles dedicating a whole week to us contributed to the knowledge we gained and the success of the program. It is without a doubt that I gained considerably from the peer-to-peer learning, as not only did I gain knowledge in the areas of effective case management strategies, I was able to utilize the knowledge and create better efficiency in the commercial matters before me through the use of extempore judgments and adapting some aspects of the UK Commercial Court Guide to suit my local setting. Another advantage of this model is that it has created lasting relationships between the three jurisdictions, as Mahinda, Anna, and I have maintained contact since the 2018 program and have become good friends. We were able to congratulate Mahinda on his recent elevation to the Supreme Court bench of Sri Lanka recently. This program has also made it possible for the Judiciary of the Gambia and the Judiciary of England and Wales to develop an invaluable partnership, which has resulted in a number of opportunities, such as the week-long training of magistrates on case management, judicial ethics, and training of trainers, which I participated in and delivered a presentation. The opportunities for continuing collaboration also allowed for my participation in the online roundtable program in 2020 as a member of SIFOCC's first international working group on case management best practices. The Judiciary of the Gambia continues to work with the Judiciary of England and Wales and intends to continue to participate in all SIFOCC activities and hopes to have a specialized commercial court in the very near future. To conclude, on behalf of my Chief Justice, the Honorable Hassan B. Jallow, and the entire Gambian judiciary, let me seize this opportunity to convey to SIFOCC and partners our deep appreciation for the support and partnership. Thank you.
Can I thank you, Justice Alami, very warmly for your very kind words, and yours, Chief Justice. And can I now remind everyone to look at the camera so that a group photograph can be taken before handing on to Chief Justice Sundaresh Menon for the next session.